day number 27 of the YouTube challenge, and I want to give you 2 quick tips for getting the best settlement possible. Tip number 1, when you go to a settlement conference or a mediation, never respond to hypotheticals. When the defense attorney or the mediator asks you for your bottom line, never give it. Your response should always be, I will only respond to an offer of money. This is something they're trying to play you when they ask you for the bottom line, because you know if you gave them your true bottom line, you'll never get it. They will undercut it every single time, so you just can't do that. So if the defense attorney wants to know your true bottom line, let's say they've offered $1 million and you're $2 million, and they say, let's cut to the chase. What's your real bottom line? You say, make an offer, increase your offer, and you'll find out eventually what our real bottom line is. So never respond to hypothetical situations ever. Even when you're meeting privately with the mediator or the judge and they ask you, what's your real bottom line? Do not respond, because frankly, you can't trust that they won't convey that to the defense. So don't respond to hypotheticals. That's rule number 1. Rule number 2, when you finally do agree to a settlement, how to confirm. This is Fisherpedia, how to confirm a settlement. Most importantly, you don't want to just agree upon the amount. You want to agree upon every single aspect of the settlement. So when we settle it, we put it on the record as required by law. But what we also agree, as you'll see right here, agree upon the exact language of the release agreement, and we annex the release agreement to the written stipulation of settlement. Why do we do that? Because what happens after the case is settled is the real battle begins, and that is the battle over all the terms and conditions that go along with the settlement. And that can drag on for months. And everyone seems to part ways as friends, but you know it's coming, the headache, which is they want this word changed, they want this condition added. So what you have to do, you have to spend the extra hour or 2 that it takes to agree upon every single term. So for example, I'll say we're not leaving this room at a mediation until the final release agreement that's acceptable to the defense has been agreed upon. So we iron it out. We annex the release agreement to the stipulation of settlement. Every single detail is covered. When we leave the mediation or the settlement conference, everything has been determined. There are nothing, and I'll specifically write that there are no terms or conditions of the settlement that are not encompassed within the written agreement. What does that do? It means that within 21 days under New York law, our client is going to get paid. If we didn't have all these terms, these extra terms and conditions that the defense attorney will try to add, that could take months and months. So try to agree upon every single condition of the settlement in writing. Don't leave anything to the imagination. And that's it. I mean, the 2 key tips here. Number 1, never agree to hypothetical offers by the defense. A hypothetical would be, if I offer you $1.5 million, would that settle the case? Do not respond. What your answer should be, offer the 1.5 and you'll find out. Tip number 2, when you settle a case, agree upon every single term, including the terms of the release agreement, in writing before you step out. It takes a little extra time, but it's mandatory. Don't leave there without ironing it out. That's it for today. I'll see you tomorrow, and please subscribe to our YouTube channel. We'd love it. Comment, leave something. Tell me what you think. Is my advice lousy? But I'd love to hear from you, and thank you for listening. Take care.